It's interesting.
Okay, ladies and gentlemen, I'd like to call to order the 73rd public meeting of the Massachusetts Gaming Commission on July 26, 2013. We will have a brief, regular public meeting. We will then adjourn briefly for some logistical changes, and we will then convene our adjudicatory hearing on the application of Raynham for a Category 2 license. We only have one item on our normal public meeting agenda, something that came up late last week, and I would like to ask Ombudsman John Ziemba if he would lead us through that discussion.
Thank you, Mr. Chairman, members of the Commission. What you have before you is the citizen notice for the town of Raynham. The town of Raynham has exercised its right to take advantage of the exception included in our regulations to move forward with a referendum in advance of suitability. And consistent with our regulations, they have submitted the citizen notice for the Commission's approval. Both legal counsel and I have reviewed the citizen notice, and it is consistent with the other ones that we've approved. They used other ones as models, and I recommend that for your consideration. By way of background, Raynham has its host community referendum scheduled for August 13th, and depending on how the proceedings go today and the further reviews, we told the community that we would be in touch with them, because one thing that we would hope to avoid, if indeed the Commission determines this applicant to be suitable, we would not want a notice to go out to the community, to go out to the citizens, saying that they are about to be deemed suitable, or they may still be needed to have their suitability determined. So in conversations with the community, we have said that a reasonable period for the mailing of that notice prior to the referendum would be basically if citizens receive it at least 1 week prior to the referendum. So that gives us a little bit of time for the back and forth with the community. Obviously, there is some legwork that the community would have to do to send out the notice to its citizens, and there is an expense. But to the degree that to the degree that Raynham needed to be prepared to take advantage of the exception, today's approval would allow that.
Okay, any questions or issues of discussion? We do have to formally approve this, which is why we had to have this special meeting. This is just a minor point, but if I don't know if the design of the flyer is still up for grabs, but the black shading behind the Gaming Commission suitability criteria is so dark, it's very hard to read. And this may be just the duplication here, but it's important for people to see those criteria. It's quite, even I have a hard time reading it on this.
Okay. Actually, one thing I'd suggest is to the degree that there are immaterial changes to the notice, perhaps you could vest the authority within the executive director or a general counsel, and we could move forward on that basis.
Yeah, that's fine. That's fine. Anybody else? Do we have a motion to do whatever it is we need to technically do here? Commissioner McHugh?
So I would move that we approve the Raynham application as printed in the meeting materials, and vest authority for non-material changes, formatting changes, highlighting changes, and the like. Approval of those changes in general counsel and or the executive director.
Second. Any further discussion? All in favor of the motion as presented, say aye.
Aye.
All opposed? The ayes have it unanimously.
Thank you.
Thank you.
Thank you.
Any other business? Congratulations to Raynham Park LLC for this next step in the process. Any other topics for discussion during our public meeting? Do I have a motion to adjourn?
So moved.
Second.
All in favor?
Aye.
Opposed? The ayes have the adjournment motion unanimously. We will now take just a minute to let the people who will testify come forward with counsel. Everybody else kind of get ready. Do you need to do any changing around of cameras or anything, Janice? cameras, mics? Janice? Do you need to do any adjusting of cameras or mics or any? Okay. Council, are you all set? Is everybody organized?
I could just have one more
Yep,
moment,
yep.
Chairman?
Take your time. What's that?
Chairman, yes. Good morning, Chairman, Commissioners. Thank you very much for your time today. As a preliminary matter, I just wanted to confirm the protocol as to exhibits that are identified and entered into evidence are a matter of public record, but documents that are referred to during the hearing will not be a part of the public record. Rather, the testimony that flows from them will be part of the public record. I wanted to confirm that, if that is correct.
I believe that's
I think that,
correct.
Mr. Chairman, that sounds like the protocol that we agreed upon yesterday, and that works
Right.
works
We
fine
just-
for the Bureau.
We just needed some kind of identification, so there's a context for the reader of the transcript.
Yes, Chairman. And additionally, any references to documents are not necessarily going to waive any confidentiality, if that is correct. And I just wanted to confirm that. And if there's information that's elicited that is confidential, they'll, myself, counsel, or the witness will refer to the portion of the record and exhibits that have been given to the IAB and the Commission where that answer will be or is.
I'm sorry.
Go ahead.
I didn't understand that,
Oh,
Ms. Lee.
If there's a question that's, that elicits confidential information, I just wanted to inform the Commission, and if the Commission is all right with this, that they're going to refer to that particular record that's been submitted to the Commission. For example, exhibits that are in the confidential report that's not made public.
In other words, if somebody asks a question, the answer to which calls for confidential information that's in a document submitted to the IEB, the witness will refer to that document instead of answering the question.
Yes, that is correct, Commissioner.
I would recommend, Mr. Chairman, that we take that one on a case-by-case basis.
That's fine.
That's
That's fine.
It's hard to deal with
Excellent.
that in the abstract.
Thank you very much. I don't have any additional preliminary matters. I don't know if council does.
Let me start this
Okay.
off in a more formal structure. Good morning. Today is Friday, July 26, 2013. This is a Phase 1 suitability hearing before the Massachusetts Gaming Commission relative to the application of Raynham Park LLC. My name is Steve Crosby, and I'm the chairman of the commission. I'm joined today by Commissioners Cameron, McHugh, Zuniga, and Stebbins. The entire commission will preside over the hearing and decision of this matter. This is an adjudicatory proceeding which is convened in accordance with 205 CMR 115.04, paragraph 3, and will be conducted pursuant to the formal rules outlined in 801 CMR 1.01, subject to the clarification contained in clarifications contained in 205 CMR 101.03 and Chapter 30A of the General Laws. We will, as a matter of courtesy for everybody's notice, we will take a lunch break if we're still running. We'll try to do it around noon so people can plan, but we'll tie it to an appropriate break in the conversation. Before we begin, I'd like to explain the procedural history that led us here, as well as the process that will govern this proceeding. Raynham Park LLC submitted a Phase 1 application to the Commission. The Commission then instructed the Investigations and Enforcement Bureau to commence an investigation into the suitability of the applicant to hold a gaming license in Massachusetts. The Bureau has conducted such an investigation into the qualifications and suitability of the applicant and its qualifiers and generated an investigative report of its findings, which it submitted to the commission. A copy of the report was provided to the applicant by the commission. Based on the report, the commission has scheduled this proceeding on its own initiative. I see that there are a number of lawyers present today on behalf of both the applicant and the Bureau. I would ask that you each please identify yourself and advise the commission as to whom you represent. Ms. Lee.
Yes, Chairman Crosby, for the record, Grace Lee, L-E-E, on behalf of Raynham Park LLC.
Alan Kohler, K-O-H-L-E-R, from Eckert Siemens, representing the applicant.
Terrence Everett, E-B-E-R-E-T-T, of Carlson Bolt LLP, representing the Greenwood Group.
Others?
Good morning, Mr. Chairman. Stephen D. Schreier, also representing the applicant with the firm of Blackrow.
Can you spell Schreier?
S-C-H-R-I-E-R.
Joel Cozal and Friedman Madison. I represent George Elatani, who's the proposed witness, and with me, Michael Morizio, also Friedman Madison.
How do you spell your last name, sir?
M-O-R-I-Z-I-O.
And David Kozal, K-O-Z-O-L, also Freeman Avenue. Thank you.
And for the Bureau?
Good morning, Mr. Chairman, Commissioners. My name is David Mackey from the law firm Anderson and Krieger. With me is Steve Anderson from Anderson Krieger, and we will be representing the Investigations and Enforcement Bureau this morning.
Anybody
Good
else?
morning, Bob Carroll, firm of Michael and Carroll.
Go ahead, Michael and Carol.
Michael Borer from Michael and Carroll.
Tony Murphy from Michael and Carroll.
That it? Okay. Thank you, councilors. At the conclusion of my opening comments, this proceeding will commence with a recitation and explanation of the investigative report prepared by the Bureau. We will ask that the Bureau outline the manner in which the investigation was conducted and outline the findings relative to each qualifier. The Bureau's presentation will largely be made by Karen Wells, who is the director of the Bureau. Director Wells is joined, as you know, by consultants from Michael and Carroll, who assisted in the conduct of the investigation. We will allow the consultants to offer any clarification or answer any questions during Director Wells' presentation. Any commissioner may ask a question of Director Wells or a consultant at any point during or following her presentation. At the conclusion of the Bureau's presentation, the applicant, through its counsel, will be afforded an opportunity to cross-examine Director Wells or a consultant relative to any information contained in the investigative report or to which they testified. The applicant may reserve its right to cross-examine until the end of their own presentation if they so choose. Next, the applicant will be given an opportunity to present its case. The burden is on the applicant to demonstrate by clear and convincing evidence both its affirmative qualification for licensure and the absence of any disqualification for licensure. To that end, the applicant has already subjected itself to a thorough background investigation, the results of which are set out in the investigative report. Those findings will be considered in determining whether the burden has been satisfied. For purposes of this proceeding, however, the applicant may call any witnesses and present any other evidence it desires in an effort to satisfy its burden. The Commission has directed that at a minimum, Robert Green, Vache Manukian, and George Carney Jr. present testimony as to the issues set forth in the notice of this hearing that was provided to the applicant. I understand that counsel for the applicant had an opportunity to meet with counsel for the Bureau and the Commission to discuss this proceeding. The purpose of that meeting in part was to clarify some of the issues that the applicant should address in its presentation. Those are primarily the issues that are set forth in the written notice of this hearing. Is that correct, counsel?
Yes, Chairman, that is correct.
While those issues should be included in the applicant's presentation, it may certainly address any other issues it believes may be relevant to its suitability determination. Similarly, the commissioners may certainly inquire into any issue that is of interest to us. At the conclusion of each witness's direct testimony, counsel for the Bureau will be provided an opportunity to conduct cross-examination of the witness. Then each commissioner will be afforded an opportunity to ask questions of the witness. Any commissioner may, however, ask any question of any witness at any time during an examination or at the conclusion of the examinations. We will allow very limited redirect and recross of a witness if it's absolutely necessary. Either party may raise any objection they desire at any time. However, the basis for all objections must be clearly stated. Finally, at the conclusion of all of the evidence, the applicant will be provided an opportunity to make a closing statement, summing up why it believes it is suitable to be issued a gaming license and should be allowed to proceed to Phase 2 of the process. Before we begin, I understand that there are a number of pre-marked exhibits that have been provided to the applicant in advance. Is that correct?
That is correct, Chairman.
I'll now ask the Bureau's counsel to introduce them.
Mr. Chairman, Commissioners, Council have agreed upon the marking and introduction of exhibits, Bureau Exhibits 1 through 4. Exhibit 1 is the 3-page notice of the adjudicatory hearing. Exhibit 2 is the cover letter dated July 3rd, 2013 from Director Wells to the Commission. Exhibit 3 is the 7-page executive summary relative to Raynham Park LLC, and Exhibit 4 is a redacted copy of the 75-page investigative report relative to Raynham Park LLC. And I don't believe that there are objections to any of the Bureau's exhibits.
Are there any objections to
No
these
objections,
exhibits?
Chairman.
Thank you. If either party plans on using any additional document, I'd ask that it at least be noted for identification if it is not ultimately introduced into evidence as we discussed. The administrative record of this matter will include all of the testimony that is provided, the exhibits that are taken into evidence, as well as the unredacted investigative report and accompanying materials that were previously provided to the applicant. The Commission anticipates that its inquiry at this proceeding will be limited to the matters addressed in the report. In the event that a line of questioning conducted by the Commission or by the Bureau moves into an area that has not been included in the reports, but that is included as part of the investigative file and is material to the suitability determination, the applicant may request a recess in the proceeding so as to review the issue. This would be an unlikely happenstance, however, as the Commission anticipates addressing solely issues covered in the investigative report. No final decision will be made here today. The matter will be taken under advisement at the conclusion of the proceeding, and a written decision will be issued. If at any point during the Commission's deliberations it determines that further testimonial or documentary evidence is desirable, it reserves the right to ask the applicant to provide such evidence prior to a suitability decision being made. We will now swear all of the witnesses in. Anyone who will be testifying at this proceeding, please stand and raise your right hand. Do you solemnly swear that the testimony you will provide before the Commission at this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Has everybody responded in the affirmative?
I do.
Thank you. All have responded in the affirmative. Before we begin, does Council have any other preliminary issues or objectives?
I do not, Chairman.
Councilor Mackey?
Okay. At this point, I would like to ask Director Wells to give a summary of the investigative report that has been introduced into evidence.
Thank you very much. Good morning, Commissioners.
Morning.
Morning.
As a preliminary matter, as I did yesterday, I would like to thank the consulting firm of Michael and Carroll for their outstanding work on this project, as well as the Massachusetts State Police for their participation in these not only this investigation, but all the investigations. The entire team has worked tirelessly and done outstanding work, and I'm extremely grateful for all of their efforts. The scope and methodology for the investigations has already been reviewed with the Commission as incorporated in both my cover letter and the report, so I will not repeat a description of the process. If any of the Commissioners would like further detail as I proceed, please do not hesitate to interrupt me. Before I get started on a summary of the applicant, I would like to comment that during this process, the IEB did find the applicant to be cooperative and forthcoming during the process, and we had no issues with respect to providing information to us in that cooperative nature of the investigation. The applicant entity is Raynham Park LLC. They're seeking a Category 2 gaming license. The applicant entity was created in November of 2012 for the purpose of tendering this application. If the applicant is successful in obtaining a license, it intends to locate its gaming facility at 1958 Broadway in Raynham. At present, this is the site of a simulcast wagering enterprise. It's a former site of Greyhound Raceway. The applicant intends to operate its slot machine gaming establishment in conjunction with a a parimutuel simulcasting racing facility. The site consists of 2 parcels of land owned by the Massasoit Greyhound Association, MGA, which in turn is owned by George Carney Jr. and the Joseph F. Carney Trust. The trust was established by Joseph Carney, the now deceased brother of George Carney, for the benefit of his 3 sons. This applicant basically consists of 2 ownership groups. There's the Carney Family Group, LLC, a Massachusetts LLC formed in December of 2012 and owned by members of the Carney family. This group will provide the property and the initial facility. The other piece of the applicant is Raynham Member Incorporated, a Delaware corporation owned by Greenwood Racing. It's called the Greenwood Racing side in the course of my presentation. This is owned by a series of holding companies that lead up to an investor named Watsky Manukian, the ultimate owner. This group will provide the financing and the management, and they provide the gaming expertise in this application. As to the operating agreement, on December 21st, 2012, the Carney Family Group and Raynham Member executed an agreement creating Raynham Park LLC, the applicant for the Massachusetts Category 2 license. The Carney Family Group agreed to provide, in the event the application is successful, the property and existing facility. A specific value was attributed to this property, and that value constitutes the Carney Family Group's capital contribution to the venture. Greenwood Racing agreed to contribute up to a certain amount for the costs attendant to and associated with the filing of the application. Greenwood Racing further agreed to contribute equity capital up to a given maximum total. In the event additional capital funding is necessary, the parties agreed that Raynham Park will explore the availability of third-party financing. Should third-party financing be unavailable, or should the rates available through third-party financing exceed a certain amount, the agreement provides the parties may make additional capital contributions. Management of Raynham Park will fall exclusively within the domain of Raynham Member, another corporation. To this end, the principals of Raynham Member and Greenwood Racing have established a holding company, Qualifier Management Enterprises Holding, LLC. This holding company has created Management Enterprises, LLC, a Delaware limited liability company which will serve as the manager of the applicant, Raynham Park. The operating agreement provides that the manager shall have the exclusive right to supervise, direct, and control management and operation of the project. The agreement also sets forth the terms upon which profits from Raynham Park are to be distributed. On the Carney side, this is held by the Carney Family Group, LLC. The entity is owned by George Carney, his wife Letitia Carney, and their nephew Timothy Carney. These are longtime residents of Massachusetts. Robert John Kelly, George's son-in-law, is Executive VP of the Carney Family Group. The Carney Family Group has entered into a consulting agreement by which they will provide for a consideration certain consulting services yet to be defined. As to the individuals on the Carney side of the agreement, George Carney has been the operator of Greyhound racing and simulcast wagering facilities, as well as various other related and unrelated businesses, and has been involved in racing since he was 17. He can be described as the patriarch of the Carney family. He is the architect of the Carney family's group involvement in this venture. Letitia Carney is his wife. While she serves on the board of some of the family businesses, she's not involved in operational matters and does not intend to be involved in the management of this project. Timothy Carney is primarily employed with the Carney family business, Carney Brothers Trucking. He does not intend to be involved in the management of the project. Robert John Kelly is the son-in-law of George Carney. He is the executive VP of the Carney Family Group. And in conjunction with George Carney, he will assume management role in the Carney family interest. He indicates his role in the operation will be limited to serving on the Raynham Park Advisory Committee. On the Greenwood Racing side, Greenwood Racing was founded in 1989. Robert Green and William Hogwood were two of the co-founders, two of our qualifiers here today. Prior to the creation of Greenwood, Green had been the CEO of William Hill Organization, a division of Grand Metropolitan PLC, GMET at the time. At the time, William Hill was one of the largest wagering and legal bookmaking organizations in the world, with its primary operations in Europe. In the late 1980s, William Hill explored potential business opportunities in the United States. One such opportunity presented itself with the passage of legislation in Pennsylvania permitting the introduction of off-track wagering. Through Green, William Hill determined that this was a potentially lucrative investment opportunity and began negotiating the purchase of Philadelphia Park Racetrack. That potential deal went by the wayside, and Green resigned and began to negotiate independently, thus the creation of Greenwood Racing. Green was introduced to Waschke Manookian by Richard Kendall. Manookian ultimately invested a substantial sum in the venture and became a majority stakeholder. Manookian's ownership is through a series of holding companies. These holding companies were created by Manookian to take advantage of then existing tax treaties between the United States, the Netherlands, and the Netherlands Antilles. Manookian advised the investigator that these tax treaties were no longer in effect, and he intends to streamline his ownership interests. With Manookian's financing, Greenwood Racing formed, and the Philadelphia Park purchase took place. Greenwood Racing has been generally successful in other gaming endeavors. The subsidiaries are licensed to operate and do operate Parks Casino and Parks Racing, 5 off-track betting locations in the metropolitan Philadelphia area, and several other off-track betting facilities in New Jersey. The major gaming operations subsidiaries of Greenwood Racing are Green Racing Management Company, employer of casino management personnel, and Greenwood Gaming Services Company, employer of gaming operations personnel. Food and beverage personnel are employed by Racetrack Food Services for racing operations and Casino Food Services for casino operations. Other subsidiary companies provide corporate support in areas including IT and financial and simulcast signal management services. Greenwood Racing, also Greenwood G&E Holding Incorporated, which is the intermediary company that in turn owns Greenwood Gaming and Greenwood Entertainment, the Pennsylvania casino licensee. Greenwood Racing is also partnered with Penn National Gaming in Penwood Gaming, operating Freehold Raceway in New Jersey and Tom's River Favorites in New Jersey. Penwood, Greenwood Racing, and Penn National are all licensed by the New Jersey Racing Commission, and the entities remain in good standing with their respective regulatory jurisdiction. Greenwood Racing, through a subsidiary, also owns Atlantic City Racetrack in New Jersey. The facility is licensed and in good standing. Greenwood Racing also owns Favorites at Vineland, an off-track wagering facility in New Jersey, also licensed and in good standing. Greenwood Racing's board of directors consists of 7 members, all of whom have been designated as qualifiers for applicant Raynham Park. They are Robert Green, William Hogwood, Terrence Everett, Richard Kendall, Anthony Ricci, David Budd, and Thomas Bonner. Greenwood Racing's officers who are responsible for implementing the orders and policies of the board of directors are Anthony Ricci, president, CEO, and treasurer, Joseph Wilson, CEO, COO, and also a qualifier, and Thomas Bonner, secretary. If capital infusion is required for this project, Greenwood entities would be capable of providing the funds. Investigators, during the course of looking at the applicant, determined an example of a recent suitability investigation that Greenwood Racing went through. In 2005, Pennsylvania passed legislation approving the introduction of slot machine gaming at, among other locations, a limited number of horse racing facilities. This category of licensure was designated as a Category 1 slot machine license, one that permits operation of slot machines at a licensed racetrack. Shortly after the passage of this new law, Greenwood Racing applied for one of these licenses. The Pennsylvania Gaming Control Board, through its agents and designees, conducted an investigation into the background and suitability of Greenwood Racing. The investigation included a review of the qualifications, integrity, suitability, and good character of the owners, key employees, and employees of Greenwood Racing. At the conclusion of this investigation, they received a recommendation of suitability, and the board subsequently considered this recommendation and awarded a temporary facility Category 1 Racino license, and then they commenced operations in late December 2006, and then Greenwood Racing ultimately received its license in June of 2007. As to the Greenwood Racing operations, if the applicant receives a license, Greenwood Racing would be responsible for operational activities at the facility. Therefore, investigators focused on the prior gaming operating history of the entity and its operating subsidiaries. A comprehensive review of Greenwood Racing's compliance history has been conducted. The objective of the examination was to, 1, identify the actual compliance history of the several regulatory and governmental agencies responsible for its oversight, and 2, assess its corporate sensitivity to the law and regulations. With regard to Greenwood Racing's history of compliance in non-gaming related matters, our investigation revealed the company has been assessed a number of fines resulting from revenue-related tax deficiencies that were examined by this investigation, and they were proven to be minor assessments, in some cases low as $25. They did not demonstrate any pattern of intentional or repetitive material non-compliance. The aggregate amount of fines for these violations was approximately $24,000. In light of the size and complexity of Greenwood Racing's operations, the number of complaints of this type, and the fines paid, the incidents do appear to the investigators in conjunction with the consultants to be de minimis, as having not have a significant regulatory impact. Investigators also discovered fines imposed against their Philadelphia Turf Club's location since 2006, including a total of $1,050 in fines for false alarms and one fire code violation in 2006 for $800. In the critical area of gaming operations, the review identified 12 instances from the commencement of its casino gaming operations to the present in which the complaints have been filed. There have been complaints filed against Greenwood Racing and Entertainment, the subsidiary of Greenwood Racing that holds the actual Pennsylvania casino license. The gaming-related complaints involve 6 charges of permitting underage gaming, 1 instance of serving alcoholic beverages to intoxicated patrons, 3 instances of using unlicensed vendors, 1 instance of permitting a person on the self-exclusion list to gamble, and 1 case of a programming error on a slot machine system enabling a patron to erroneously win a jackpot. The underage complaints are fairly typical violations that result from the enormous amount of traffic on a casino floor. The inspection of the casino revealed that Greenwood Racing designed its facility to minimize available points of entry and staff those locations with fixed post security employees. In the consultant's view, this configuration, in conjunction with the fixed post assignment, constitute the optimum design and deployment for a facility of its size. Ownership and top-level management were interviewed specifically with regard to the issue of underage gaming and alcohol consumption. They all appeared to be both very knowledgeable and sensitive to these issues. Toward this end, they have instituted an ongoing identification training program for all security and casino floor employees. In one of the unlicensed vendor complaint matters, Greenwood Racing had conducted business with one of its own then unlicensed subsidiaries. In the other matter, the company engaged a computer company that had at the time been on the Pennsylvania Gaming Control Board's prohibited vendor list. In the former matter, Greenwood advised it did not realize the subsidiary company required licensure. In the latter case, they stated they had failed to take adequate measures to verify the vendor's status. As a result of these incidents and complaints, Greenwood Racing has completely revised its vendor and purchasing operation procedures to ensure future compliance with vendor regulations. With regard to the erroneous jackpot, it was determined this incident arose out of an inadvertent misprogramming of the slot machines. There did not appear to be any cheating or any form of game manipulation involved. As a result of the 12 gaming-related complaints that I've discussed, Greenwood Racing has been fined and has paid the aggregate sum of approximately $204,000 to the Pennsylvania authorities. Lastly, Greenwood Racing was engaged in a lengthy dispute with the Pennsylvania Department of Environmental Protection, Clearwater Fund, DEP. This dispute related to the methods by which Greenwood Racing had been disposing of the horse manure generated by the approximately 1,400 racehorses residing at the Philadelphia Park facility. Greenwood disputed that its methods were in any way inappropriate. Rather than continue the dispute and the expense that it was engendering, Greenwood decided to resolve the matter by way of a consent agreement signed on May 16, 2011. The agreement required Greenwood Racing to take such remedial action as necessary to minimize any potential pollution and rainwater runoff. Moreover, Greenwood agreed to pay a fine of $387,000 to the DEP Clean Water Fund and $22,700 to Bucks County, Pennsylvania Conservation District authorities. In conclusion, we have reviewed all the relevant gaming and non-gaming actions taken against Greenwood Racing and its subsidiaries. We've also conducted numerous interviews with key qualifiers, as well as representatives of both the Pennsylvania Gaming Control Board and Pennsylvania State Police. The on-site inspection of the park's casino revealed the casino is designed to facilitate maximum oversight by security for entry onto the casino floor. The number of complaints against that facility, in particular those that involve action on the casino floor, did not appear to establish either a systematic pattern of regulatory violations or a lack of sensitivity to regulatory oversight. In fact, considering the volume of traffic on the casino floor and the size of Greenwood Racing's business, the number of regulatory complaints filed is less, in the consultant's view, than might be expected from a similar operation of this size and scale. Greenwood Racing was also the subject of a routine United States IRS audit, which identified no issues or concerns. As to the Greenwood Racing financing, in summary, the acquisition of the Philadelphia Park by Greenwood Racing was financed by equity and debt contributed by the shareholders of Greenwood Racing and by a purchase money mortgage from ITB, the seller. The purchase money mortgage was subsequently paid off. Greenwood Racing's financing currently consists of both bank and shareholder financing. A term loan and a revolving credit facility were issued to Greenwood Racing in September of 2011 by a syndicate of major financial institutions led by Bank of America. As of December 31st, 2012, the term loan had amounts outstanding, but nothing was outstanding on the revolving credit facility. In addition, the shareholders of Greenwood Racing or their affiliates provided 2 shareholder loans to Greenwood Racing, one in 2009 and one in 2010. The shareholder loans are unsecured and subordinated to the bank financing. As with other applicants, if this applicant is permitted to continue to the Phase 2 stage, they should be required to demonstrate the specific methods, sources, and overall immediate financial ability to complete the proposed project in a timely manner. As with the other investigations that the IEB has conducted, they identified through scope of licensing both entity and individual qualifiers which would need to be individually investigated, and that was done in this case as well. The entity qualifiers, as I've referenced them in my presentation already, I'll just go through the entities that were investigated and found to be recommended to be suitable as a result of the investigation. It was Raynham Park, LLC, that's the applicant entity. The Carney Family Group, previously outlined as the land providers. There's Raynham Manager. This business is described as the entity intended to solely manage, direct, and control the business entity, Raynham Park, LLC, in pursuing a Massachusetts Category 2 gaming license. Company is also identified as managing the design, construction, and future operation of the facility if granted a license. That was created in 2012. There's a Raynham Member. That's formed for the purpose of developing the gaming facility, and that owns half of Raynham Park along with the Carney Group. There's Greenwood Racing, which I've described in detail, the owner of Raynham Member. There's Management Enterprises, LLC, and Management Enterprises Holdings, LLC. They're formed to manage the gaming ME, Management Enterprises, was formed to manage the gaming facility for the applicant, owned by Management Enterprises Holdings. Those companies are not operational and won't be unless or until the license is received. There was International Turf Investment Company, a significant owner of Greenwood Racing. There's ITIC/ITAC, another connected company in the Manukian string of holding companies, along with Coringal Holdings BV and Coringal Holdings Curaçao NV. And Rock Limited, that also has an ownership interest in Greenwood Racing. All of these companies were vetted through an investigatory process as described in the report, and in my cover letter, no material issues were discovered which would negatively impact a suitability determination. As to the individual person qualifiers, I'll start with the Carney Group. George Carney, I've already reviewed his involvement and some of his background. He's an experienced businessman with a long history of involvement in different entities, as further outlined in the report. George Carney's ownership interests in dog racing, simulcasting, and wagering, and alcohol beverage businesses have required that he and his entities be licensed or qualified by the Massachusetts Gaming and Racing Authorities and the Alcoholic Beverage Control Commission, as well as the town of Raynham and the city of Brockton. The investigation reviewed and evaluated the applicant's submitted materials, database records, and where necessary, confirmatory agency records related to these license holdings, and the review disclosed no material findings adverse to his suitability. A 2010 issue regarding the Massachusetts State Racing Commission inquiry into delinquency of certain racing taxes and fees at the Taunton Dog Track was investigated. The matter was initially resolved by a payment plan, but upon further review, the records show that Raynham Park is current in all parimutuel obligations to the Commonwealth. At this point, I just want to refer there in the redacted, in the unredacted version of the report, in Exhibit 1, there's a reference to a tax matter. I'll just refer to that and not get into detail because it has been redacted for purposes of this hearing, but I'll refer to that for the Commission's consideration. Generally, the applicant qualifier passed muster with respect to the statutory requirements, including financial integrity, responsibility, integrity, honest and good character, and business ability. I will refer to the, at the end of my presentation, to the condition, one of the conditions of recommended conditions of suitability as recommended by the IEB. Timothy Carney, part owner of the Carney Family Group. He's primarily employed with the Carney family business, Carney Brothers Trucking, does not intend to be involved in the management of this project. He is currently licensed by the Commonwealth of Massachusetts State Racing Commission for dog racing simulcast, and his license is in good standing with no reported regulatory violations, credible employment history, and as with the other the individual qualifiers, no material issues were found during the course of the investigation. Letitia Carney, as I said, was part owner of the family group, the Carney Family Group, and the wife of Mr. George Carney. While she serves on the board of some of the family businesses, she's not involved in the operational matters. She does not intend to be involved in the management of the project and has never been a holder of a gaming license. Robert John Kelly, the son-in-law of George Carney, is the executive vice president of the Carney Family Group. In conjunction with George Carney, he will assume a management role in the Carney family's interest in the project. He indicates his role in the operation will be limited to serving on the Raynham Parks Advisory Committee. He is currently licensed by and in good standing with 19 gaming authorities. 6 of those have renewals pending. Mr. Kelly is licensed in those jurisdictions due to his position as a member of the Board of Directors of Gaming Partners International Corporation. This is a company that is a gaming vendor providing chips, dice, card tables, layouts, and other accessories to casinos. Kelly is therefore licensed in the jurisdictions where the company does business. Kelly has advised that the company does not supply and will not be supplying slot entities. As to the Greenwood Racing side of the applicant entity before you here today, first individual discussed is Washki Manukian. He also goes by Robert or Bob Manukian. He is a very wealthy and successful businessman. He's enjoyed considerable success investing in real estate, both in the United Kingdom and the United States. Through its many holding companies, he is a substantial owner of Greenwood Racing, which in turn owns Raynham Member. He expects to be involved in the construction of the facility, but not the management. He indicates he is comfortable the applicant has assembled a first-rate management team. Aside from businesses associated with this application, he is actively involved in many other business relationships. He sits on the board of numerous charitable foundations. He holds a key employee qualifier, Pennsylvania gaming license. He has not been personally cited for any regulatory violations, and he has been found suitable by the Maryland Racing Commission. During the course of the investigation, investigators checked into several negative media reports regarding Mr. Manukian. There was an allegation that he was on the Royal Canadian Terrorist Watch List, which was confirmed to be false by the Canadian authorities. There were media reports that he was systematically dodging U.S. taxes through a series of offshore shelters. Investigation confirmed that he indeed created a complex ownership structure for his holdings in Greenwood Racing that enabled him to take advantage of the then existing tax treaties between the United States, the Netherlands Antilles, and the Netherlands. In particular, Manukian's companies located in jurisdictions where no taxes were assessed took mortgages on certain Greenwood Racing holdings, often at seemingly high interest rates. Therefore, the interest portion of the mortgage payments made by Greenwood to those entities was untaxed to the entity that received the interest in the country in which it was located. At the same time, Greenwood Racing deducted the interest payments from his taxable income, therefore creating the appearance that the U.S.-based company Greenwood lowered its tax while the foreign-based company paid no tax. In fact, though Greenwood, in making the interest payment to the Manukian entity, withheld 30% of the interest payment as tax assessed by the U.S. on a foreign person or entity's U.S. source income. Although Manukian did not pay the tax directly, paid it indirectly in that the amount of interest paid to him was reduced by 30%. Thereafter, Greenwood remitted the withheld tax to the U.S. taxing authorities. Therefore, having conducted a review of Manukian's tax history, it is the conclusion of the consultants and the investigators that he complied with the existing United States laws. I expect, however, that this issue will be the subject of the commission inquiry today, as there's a difference between complying with the laws and tax avoidance, and I think that's going to be some of the discussion here today. A 1989 seizure of his airplane was also reported in the press, and there were some negative media reports about that. It was confirmed through the investigation that the passengers on that plane had indeed been cleared through immigration by customs officials, and that the seizure of the aircraft had been a mistake. In addition, there was an allegation that he was fined by Britain for tax violations. The investigators confirmed that was in fact untrue. He was never assessed any fines for failure to pay his taxes. The next member of the Greenwood Racing side is Robert Green, the Chief Operating Officer and part owner of Greenwood Racing. He is a successful and experienced gaming executive. Under his direction and control, Greenwood Racing has been successful and has a good compliance record. He's licensed by the Pennsylvania Gaming Control Board, the Pennsylvania Horse Racing Commission, the New Jersey Casino Control Commission, New Jersey Racing Commission. He also reports licenses from the Virginia Racing Commission and the Oregon Racing Commission, but inquiries to those agencies were not returned as of the date of the report. There was one issue identified in the report of significance: his relationship with a business associate, a friend who was convicted of money laundering, false declaration in bankruptcy proceedings, and concealment of assets in bankruptcy proceedings. Initially, their relationship involved friendly business competition, but ultimately evolved into a personal friendship. They engaged in a business relationship from 1989 through 1995. The matter was the subject of an investigation by the New Jersey Division of Gaming Enforcement in the late 1990s. A hearing was held specifically regarding whether Green had acted improperly in his associate's behalf in their business dealings. At the end of the hearing, the division recommended that Green be found qualified, and the recommendation was later adopted by the full commission. Green indicated in his sworn interview with our investigators that he has infrequent contact with this associate, but still considers him a friend and has seen him 1 or 2 times since his release from incarceration. This issue, while reviewed thoroughly by New Jersey, is certainly appropriate for inquiry by the Massachusetts Gaming Commission, given the serious nature of the concerns. The next individual is William Hogwood. He's the Deputy Chairman and Director of Greenwood Racing. He is licensed and in good standing with a number of various gaming authorities: the Pennsylvania Commission, the New Jersey Control Commission, the Pennsylvania Horse Racing Commission. Those are all current. He also has expired license from the Southampton and New Forest Magistrates Court. He's a credible history of managing successful businesses and of regulatory compliance. Next individual is Anthony Ricci. He is the Chief Executive Officer of Greenwood Racing, as well as Greenwood Gaming and Entertainment. If the applicant is successful, he will function as an officer and director in the operations of Raynham Park. He has been employed by Greenwood Racing since 1993, functioning in a variety of positions. He would be functioning in those same positions for Greenwood Gaming since 2005. He's licensed and in good standing by the Pennsylvania Gaming Control Board, the Pennsylvania Horse Racing Commission, and the New Jersey Racing Commission. He also, like the other qualifiers here, has a credible history of managing a successful business and regulatory compliance. Next qualifier is Joseph Wilson. He's the Chief Operating Officer of Greenwood Racing. He will serve as a licensed key gaming employee should the applicant get a license. He's been employed with Greenwood Racing since 1999 and served as the Director of Wagering from 1999 to 2002. Subsequently, he was the Vice President of Operations from 2002 to 2007. Wilson has been the Chief Operating Officer since 2007. He's licensed and in good standing by the Pennsylvania Horse Racing Commission and the New Jersey Racing Commission. Next individual is Thomas Bonner. He is the Vice President, Secretary, and Director of Greenwood Gaming and Entertainment. He holds the position of secretary with the Greenwood subsidiaries. If a license is obtained, he would serve in the same capacity with the applicant. He's licensed as an attorney in New Jersey and Pennsylvania with no record of disciplinary action in either state. However, he was listed as a defendant in a malpractice suit in 1996, which was later dismissed. He's currently licensed by and in good standing with the Pennsylvania Gaming Control Board as a key employee and has a casino key employee license in New Jersey, which expired in the year 2000. Next qualifier is Terrence Everett, an attorney and partner in the firm of Carl Smith Ball LLP. He's also a director with Greenwood Racing. If the applicant is successful, he will serve as an operator and director in the operations of Raynham Park. He's had a personal and professional relationship with Mr. Manukian for 30 years. He's licensed and in good standing with the Pennsylvania Gaming Control Board. Next qualifier is Richard Kendall, a director of Greenwood Racing. In connection with his appointment as director, Kendall advised that he meets with the board at least 6 or 7 times a year and serves on the audit, compliance, and human resources committees. He is part owner of Rock Limited, which in turn is part owner of Greenwood Racing. He started as an accountant and worked his way up quickly through the ranks in the industry. His role with Raynham Park is yet to be determined. He currently holds a qualifier license in good standing with the Pennsylvania Gaming Control Board. Over the past several decades, he has held numerous licenses, permits, and certificates of consent from the British gaming authorities and local magistrates' courts to conduct casino gaming and legal bookmaking in the United Kingdom. The investigation reviewed and evaluated his submitted materials database and, where necessary, confirmatory agency records related to these license holdings, and the review disclosed no material finding adverse to his suitability. Next qualifier is David Budd. He is currently an outside director of Greenwood Racing and Parks Casino, Philadelphia, PA, since October of 2011. Prior to this, he was employed with Hong Kong and Shanghai Banking Corporation from 1972 to 2011. He's described as a non-executive director with Greenwood Racing. He's licensed and in good standing with the Pennsylvania Gaming Control Board, was also licensed in 2012 by the Pennsylvania Racing Commission. Next qualifier is James Lane, an outside director of Greenwood Racing. He's a partial owner of Rock Limited, plans to take no role in the operation of Raynham Park if licensed. Currently, besides Greenwood Racing, he has divested himself of all his previously owned gaming-related enterprises. He owns and is involved in other businesses. He is currently licensed by and in good standing with the Pennsylvania Gaming Control Board and the Pennsylvania State Racing Commission. Over the past several decades, he had been granted and held numerous licenses, permits, and certificates of consent from the British gaming authorities and local magistrates' courts to conduct casino gaming and legal bookmaking operations in the United Kingdom. The investigation reviewed and evaluated the materials and discovered no material findings adverse to his suitability. Next individual is Brian Bartlett. He is the CFO, VP of Group Finances for Greenwood Racing. He's held that position since 2013, January, I believe, of this year. He was previously employed in the financial department of Aramark Corporation from 2000 until 2013. He joined Greenwood Racing Group as the result of a job search conducted for him by a headhunter. Bartlett reported he knows very little about the gambling business, but sees the new position as a challenge and a great opportunity. He serves as the CFO for the Raynham Group as part of his duties. He has never had a gaming license. That's the list of the qualifiers that were investigated as part of the suitability determination. The investigation disclosed no material issues with respect to good character, honesty, integrity, and reputation beyond what is noted in the report. No criminal histories of any of the qualifiers would prevent any finding of suitability. Both the Greenwood side and the Kearney side have been licensed in other gaming jurisdictions. Greenwood, with respect to both racing and gaming, their regulatory records demonstrate a sensitivity to and history of compliance. There is no record of any prohibited political contributions or civil litigation history would be adverse to the qualifiers being found suitable. While the investigation did disclose various instances of litigation, the cases reviewed appeared to be standard and commonplace in the context of the business activities the qualifiers conduct. As to sufficient business ability and experience, the applicant and its qualifiers have long histories of successful business activity. While it is certainly clear that Raynham track has not, as of late, been lucrative, this has been the fate of all tracks in the Commonwealth. The track's financial difficulty was, in part, the impetus for the passage of the Expanded Gaming Act in the first place. The investigation did not disclose any evidence to support the notion that any failures at the Raynham track were the result of inadequate and insufficient business ability on the part of the owners and operators. On the Greenwood side, the gaming activities in which they are and have been engaged have been very successful and illustrate the business acumen of the owners and operators. Some of the principals of the Greenwood entities, especially Robert Green, began in the gaming business in 1961 with legal bookmaking in England. Greenwood, through various subsidiaries, operates Parks Casino, Freewood Raceway, and Atlantic City Racetrack in New Jersey, and other off-track betting facilities in the Garden State. The recommended conditions from the IEB before the commission would deem the applicant suitable are, as noted in my cover letter, the recommendations that Robert Green be prohibited from transacting any other further business with the associate previously discussed. I'll note that New Jersey has the same condition imposed. George Carney pay any outstanding tax obligations. I'll refer to the confidential part of the Exhibit number 1. The applicant present evidence at the hearing as to Mr. Green's suitability, particularly regarding his association with that other individual. And the applicant present evidence at this hearing that Mr. Manukian's business practices are consistent with statutory mandates here in the Commonwealth. So that concludes my summary of their report.
Thank you, Director Wells.
Thank you.
Counselor, do you have a direct cross-examination?
We'd like to reserve a right to we actually present our case, if that would be agreeable with you, Chairman.
That's fine. Commissioners, any questions?
No questions.
Okay, I think it's your turn.
Thank you. Before we started, I did want to take a moment to thank the Commission and its staff, especially Director Wells and the IEB unit, Michael Carroll, the State Police, and Anderson and Krieger. A lot of things had to happen in order for us to be present here and articulate. The staff and the Commission as well has been exceedingly accommodating, professional, cooperative, and I just wanted to acknowledge how helpful that has been for our process. Even prior to preparing for this proceeding, the Commission and the staff have been extraordinarily generous with their time and patience. So thank you very much for your commitment and public service. I appreciate it. I want anyone's watching on the live stream to recognize that long after the hours that most people go home, I get returned calls from your staff very late at night, still at work. So thank you very much for that. And I know it's because they're really committed to the process, the Commission, and the Commonwealth. So thank you.
Thank you.
And as committed as you are, as are we. And today we're here to present clear and convincing evidence. And we thank you for that opportunity. We not only thank you for that opportunity, we embrace it, and our team collectively has been very enthusiastic about preparing. Off the top of my head, when I did the math, collectively I think our team traveled 59 hours, albeit Mr. Manukian did 36 himself. And I say that because we are very appreciative, and we do want to take advantage of this time, and we don't take it lightly. So with that being said, I'm going to hand it over to my co-counsel to present our witnesses. Thank you, Chairman. Thank you, Commissioners.
Alan Kohler, Chair.
Mike, just make sure the mic.
Alan Kohler, Chairman Crosby. We're going to present 5 witnesses for you today in the following order. The first witness will be Anthony Rickey, who's to my left. He's the Chief Executive Officer of Greenwood Racing. The second witness will be Thomas Bonner, who's the Vice President and General Counsel of Greenwood Racing. The third witness will be Vache Manukian, who's the majority shareholder of Greenwood Racing. The fourth witness will be Robert Green, who's Chairman of the Board of Greenwood Racing. And the final witness of the day will be George Carney Jr., who's the majority equity holder of the Carney family group. Consistent with the discussion at the pre-hearing conference, we're going to have, I understand that you want to hear, more from the witnesses and less from the attorneys, so we're going to try to do this in a presentation format rather than an examination format. And I and the other lawyers will only speak as necessary. We hope that format, accommodates your needs. With that, I'm going to turn it over to Mr. Ricky for the first presentation of the morning.
Good morning, Commissioners, and thank you for allowing us to appear today before you to discuss what is truly a game-changing opportunity for both the Commonwealth of Massachusetts and the town of Raynham. I'm the Chief Executive Officer of Greenwood Racing Incorporated, which is the parent company of Parks Casino and Racetrack, which happens to be the #1 most successful casino in the state of Pennsylvania. The state of Pennsylvania is the top tax gaming revenue producing state in the country. So we know a little bit about generating tax revenue. I joined the company as Chief Financial Officer in 1993, and I was appointed Chief Executive Officer in January 2012. When we learned that Massachusetts had authorized casino gaming, we looked for an opportunity where we could best replicate our success at Parks. We were immediately drawn to Raynham Park as the best location for a slot casino in the Commonwealth. There were so many parallels to our success at Parks. This, too, is an existing gaming facility that has enjoyed a long cooperative relationship with its town in a location that produced what was once the #1 dog track in the world. The property has excellent highway access in a beautiful town that offers an attractive destination for customers and an impressive community that provides a strong labor pool. We were also impressed with George Carney and his fine team, who had extensive experience in the racing business and enjoyed an outstanding reputation. There was a feeling of deja vu in our first visit, and we decided to look no further, even though we could have been on our own in another location. We knew from our own experience that there was no better location for a slot license in the Commonwealth. The Commission can be confident in the fact that our team has successfully completed this task before. We are proud of our legacy as a successful racetrack operator since 1990 and a casino operator since 2006. We received our casino gaming license in September 2006, and within 3 months, opened our temporary casino in the racetrack grandstand in December 2006. The grandstand casino was subsequently expanded due to heavy customer demand, while we simultaneously developed a new, permanent casino that rivals the look and feel of a Las Vegas casino. I would like to refer the Commission to our Exhibit 1, which you can peruse at your convenience. It includes several photographs of our property, and these serve to validate this claim. The key to our success is our outstanding team, which is the best in the business. We hire the best talent, we train them well in best practices, and ensure they're highly motivated and engaged. We're deeply committed to first-class customer service, along with community outreach, social responsibility, and of course, compliance with regulations. None of these goals can be achieved without a talented, highly motivated, and well-trained team. Our track record in this area is unsurpassed. Our business approach is straightforward. We start with a beautiful property, make sure that it's well-maintained, clean, and safe, then provide the latest and best games with first-class service to ensure that every customer has an experience that creates not only satisfaction, but long-term loyalty. This success has created a substantial increase in new jobs, 80% of which are for local residents, and we have given preference to local vendors for services. The significant increase in the tax base, along with the increase in direct jobs and local business, have all dramatically improved the economic fortunes of our town. There's no doubt that our state and local community are in a better position thanks to the expansion of gaming on our property. There's also no doubt that the Parks team will accomplish the objectives of the enabling legislation here in Massachusetts in maximizing job creation and tax revenue for the Commonwealth, while conducting ourselves in a way that reflects favorably on the industry, just as we have in Pennsylvania. Our company is highly respected in the banking community for our sound financial management, and our balance sheet is among the best in the gaming industry. We have a capital structure that consists of 2 tranches, term loans from a group of major banks, and a long-term subordinated notes from our shareholders. These notes were created in late 2009 when we required additional funding to expand our facility and pay a license fee in conjunction with the addition of table games in Pennsylvania. At that time, our credit facility, which had been completed in 2006, carried an interest rate that was substantially below what was then a thawing but significantly higher price market following the collapse of the credit markets in late 2008 and into 2009. Furthermore, that credit facility included a provision that required the entire loan to be repriced to the new higher levels if any new debt was added. The only exclusion from this provision was if the shareholders were to add additional subordinated debt. Therefore, it was much less expensive overall for the company, and it offered significantly greater financial flexibility to borrow money directly from its shareholders. Our credit facility was subsequently refinanced with our existing bank group in 2011, as Director Wells said, and we were able to lower our overall interest expense and provide additional financial flexibility offered in the lower cost bank market by keeping these shareholder notes in place. The Internal Revenue Service has reviewed and approved the propriety of this structure in its most recent routine audit that carried through the year 2010. I would also like to note that there were no adjustments proposed as a result of this audit. Furthermore, I would like to point out that taxes are withheld at the mandated rate of 30% for all interest payments made to Coringal as required by law. Our company's record as a taxpayer is impeccable. In fact, we paid almost $300 million of various taxes in 2012 alone, and almost $1.3 billion in taxes over the past 5 years. This information is detailed in our Exhibit 2, which again you can peruse at your convenience. In short, we're a tax revenue generating machine, which is what we intend to replicate here in Massachusetts. I would now like to refer the Commission to Exhibit 3, which I would like to review with you, which reviews the proposed capital structure for Raynham Park LLC.
Perhaps we
Mr.
could
Chairman,
formally
Commissioners,
admit,
it's not obvious to me that the Commissioners have these exhibits in front of them, and I don't think they've been moved into evidence.
Yeah, we noticed that, we were waiting.
We do.
Didn't want to interrupt Mr. Ricky's flow. At yesterday's hearing, and we did move, the commission exhibits into evidence. At yesterday's hearing, as I watched it, the applicant's exhibits were also moved into evidence at the beginning of the hearing. I assume we need to repeat that process here so that.
That's fine.
And we have no objections to the admission of their proposed exhibits.
Do you have extra copies of it, just for simplicity?
I think we have them.
Yeah,
It's
I
right
know.
after the report.
We do have extra copies, but my understanding was it had been previously circulated. Mr. Ricky's first reference to Exhibit 1 was the pictures of Parks Casino in Bensalem. Exhibit 2, which was also referenced, is a printout of the Pennsylvania Gaming Control Board's website, which shows not only our gross terminal revenue and tax payments for the last fiscal year, but also those of all the other casinos in Pennsylvania. If you wish to compare, you'll hear us say we're the most successful casino in Pennsylvania, and we think Exhibit 2 proves that out. Mr. Ricky's now going to move on to Exhibit 3 and spend a little time on that exhibit with you.
Just hang on one sec.
Shall I proceed?
Yeah.
If Raynham Park LLC is awarded a Category 2 gaming license by the commission, the company will be capitalized in the amount of up to $181 million to fund the construction of the gaming facility and the commencement of operations. Of that $181 million, it's contemplated that up to $125 million will be funded by bank debt, with the remaining $56 million funded by principal equity contribution. Of the $56 million equity contribution, up to $45 million will be contributed by Greenwood Racing, and the remaining $11 million will be contributed by the Carney Group, representing the value of the Raynham Park land and business. The Raynham Park capital structure does not include any shareholder loans from shareholders of Greenwood Racing or the Carney Group. The equity contribution will be accounted for in capital accounts established for Greenwood Racing and the Carney Group. Both capital accounts will accrue a preferred return at a rate of 15% per annum. This preferred return merely affects the distribution of excess cash derived from profits after all taxes and all expenses are paid of the Raynham Park LLC. Unlike interest on a loan, the preferred return is not tax deductible and does not reduce the amount of taxable income or tax obligations of Raynham Park LLC. In summary, the above structure will assure the payment of all tax and operational obligations and merely provides a mechanism for the distribution of excess equity to the principals. That concludes my presentation. Certainly available for any questions.
And I just have one question for Mr. Rickey before cross-examination. Mr. Rickey, you referred to the company withholding for taxes interest paid to Coringle, and I know there was also references to Coringle in Ms. Wells' testimony. Can you explain who Coringle is, what Coringle is?
Coringle is the entity that represents Bob Manukian's ultimate beneficial ownership interest and is the lender of record in the shareholder notes.
With that, Mr. Rickey has nothing for.
Okay. Counselor?
We have no questions of Mr. Rickey.
Questions from the commission?
I have no questions.
I just have one. On page 21 of the report, it talks about some of the issues that arose in your operations in Pennsylvania. And the last couple of sentences on that page say, in the latter case, they stated that they had failed to take adequate measures to verify the vendor's status. As a result of these incidents and complaints, Greenwood Racing has completely revised its vendor and purchasing operation procedures to ensure future compliance with vendor regulations. Sorry.
Chairman Crosby, our next witness is our compliance witness, and he will, that will be part of his presentation, and be glad to answer. If I hear where you're going, be glad to answer.
Well, maybe he can speak to it as well. But
okay.
As the CEO,
I'm happy to.
Yes. You're an experienced operation. Right. One of the things you take credit in is running good operations. Why would you have to, shortly after you open operations, completely revise its vendor and purchasing operation procedures to ensure compliance? What was wrong?
There were things slipping through the cracks. We had a racing and a gaming operation, and Tom Bonner will go into that in greater detail. I think as Director Wells stated, we're not ever happy. We have zero tolerance for these kind of issues. We want no penalties, no fines, no infractions. Obviously, a few things did slip through the cracks, and as Director Wells said, they seem to be small in scale, given the scale of our operation. That being said, when we saw that there were some issues there, we immediately responded and corrected the problem, and we are in full compliance today. Tom Bonner will elaborate on that in his presentation.
Okay. Anybody else?
I
Yes.
had one question.
Sure.
You focused on the successfulness of the slots operation. You did not mention the racing. How is the thoroughbred racing faring?
Thoroughbred racing across the country has been in a state of decline. With that being said, the state of Pennsylvania is probably in the strongest position of anyone thanks to this legislation that was passed in 2004 and created significant subsidies for both the horsemen, the racetrack operators, and for the breeders. So the breeding industry has actually grown dramatically in the last 10 years. However, the customer side of the business, in terms of handle and wagering, has declined. A combination of economic situation and I think competition from expanded gaming in the state. We already had Atlantic City within our market area open in the late 70s, and that did cause significant issues for the racing operation back in the 70s, and I'm sure George can speak to this. When Foxwoods and Mohegan opened in Connecticut, we saw a significant decline in the racing business in the Philadelphia market when Atlantic City began. We had attendance of approximately 25,000 people on a Saturday, and that presently is about 2,500 people. However, you know, the customers seem to prefer casino gaming to horse racing. However, our horse racing business, relative to the others, has fared very, very well. The decline certainly is less than anywhere else.
Can you give the commissioners a sense of the size of Greenwood's, comparative size of Greenwood's horse racing operations?
Well, we have 1,400 horses on our property. We race year-round basis. We don't close for more than 200 days a year, and we've been doing that since I arrived in 1993 and Bob Green took over in 1990. It's something that, from a handle standpoint, we also have 5 turf clubs, in addition to the racetrack operations throughout the Philadelphia market, a telephone account wagering operation, and in New Jersey, we, as Director Wells stated, we own the Atlantic City racetrack, another turf club there, joint venture interest in Freehold Raceway and the turf club in Toms River, New Jersey, and we have an account wagering operation in Oregon. Collectively, we are one of the largest racing operators in the country, and we are still profitable, but it is a challenging environment.
Thank you.
Thank you.
Set. Mr. Stebbins?
Quick question, and I just had a chance to look at the numbers. In terms of your comment that the Parks Casino is the #1 in Pennsylvania, do you base that on total revenue, total tax payable to the Commonwealth of Pennsylvania?
In both cases, we're #1.
Okay. And you also, it's fair to say you have the largest number of machines as compared to any of the other
In the
slots?
state, that's correct.
Okay. Are you, is Greenwood currently competing for the latest round of applications for a casino in Philadelphia?
Yes, we are. Yes, we are. We're in partnership with the Cordish Group for a license in the Philadelphia area.
Thank you.
Anything else? Thank you, Mr. Rickey.
Thank you very much.
Are we ready for another one? Do we want a break? How are you doing?
Okay.
Okay?
How are you doing?
Okay. All right, well, let's go ahead with Mr. Bonner. Okay.
Chairman, we ask for your patience. We are going to be rotating people in and out, but try to do it quickly and seamlessly.
Morning, Mr. Chairman and Commissioners. Chairman, if you'd like, I can address the question that you posed most recently to Mr. Rickey. The procedure that we had in place before we made the change referred to in Director Wells' summary required that on the front end of a purchase transaction, the purchasing department would check the Gaming Control Board website to make sure that the entity or individual with whom we were going to contract was either registered as required by the Gaming Board or at a minimum not on a prohibited list at the Gaming Control Board. We had circumstances in which that check was done at the time the contract was originated, but by the time it came time to make payment, things had changed at the Gaming Control Board. Either a registration was required that hadn't been filed yet, or someone who had not been on the prohibited list was put on the prohibited list by the time payment was due. that was the situation with one of the infractions that was mentioned in the report. The way we revised that procedure was to tighten up the front-end check done by the purchasing department. Even though they had been doing it, we have formalized that process with new documentation that gets routed through several departments. But the most significant change that we made was to require the accounts payable department, which actually cuts the checks, to do its own check of the Gaming Control Board website before that check is processed, to make sure that the appropriate registration is in place and that the entity being paid is not on the prohibited list. That was a significant change that was made. And since that was put in place, we have stopped several checks that without that process would have been issued without that check.
Okay, thank you.
Okay.
Just out of curiosity, why didn't you have that same system in place already at all your other facilities?
In hindsight, well, the casino operation in Ben Salem is the only operation that is subject to those payment requirements through the Gaming Control Board. They don't exist at the racing operations and the turf clubs. So that would be the only location where that kind of a second check of the gaming control site would be required. In hindsight, it would have been better to have it in place from the first day of operations, but we caught up and put it in place once we realized the deficiency.
Okay.
It's probably a good segue to my comments, Commissioners. I think, as has been noted in Director Wells' report, we at Parks Casino take regulatory compliance very seriously. It's a major focus of what we do at Parks Casino.
Excuse me, so you work just at Parks? You're responsible just for Parks?
No, I'm responsible for the entire
For Greenwood.
operation. I am general counsel for the entire racing operation and gaming operation. I'm on the board of directors of the parent and general counsel and secretary for the major
For
operating
Greenwood,
subsidiaries.
okay.
Yes, sir. We engage in literally hundreds of thousands of regulated transactions on the casino floor each day. Every ticket redemption, every transaction at the cage, every purchase of chips is a regulated transaction. And with approximately 20,000 people on average in our casino in a given day, we have many, many, many regulated transactions that occur. Our objective is to get every one of them right. And as you can see from the numbers reported by Director Wells, we do a pretty good job given the volume of transactions, but of course we can do better. We want to get that down to zero. One of the ways that the company focuses the entire operation on regulatory compliance is through our compliance committee. We have a 3-member compliance committee. All members are outside directors. We have no inside executive employee members of the audit committee. They are all outside directors. We meet monthly with the compliance committee, and the compliance committee is extremely active in compliance matters that grow out of our operations. The monthly meetings of the compliance committee are attended by staff members from the legal department. I attend and one of our assistant counsel attend. They're attended by the director of internal audit, and they're attended by the director of surveillance. The internal audit and surveillance directors issue a monthly report to the members in advance of the meeting, documenting certain statistics that the committee has directed we document during the month. I personally write the minutes of each of those meetings. They're detailed and they are filed with the Gaming Control Board within 20 days of each meeting. The Compliance Committee actually charts performance in certain compliance areas and measures them at each monthly meeting that we have with our staff. We believe that that is a significant factor in promoting the best regulatory compliance that we can have. Director Wells had mentioned our regulatory compliance history in her comments, and we are extremely proud of the history that we've developed since 2006. Director noted a dozen infractions that are on the list where regulatory penalties were imposed. We'd like that to be 0 in coming years, and we continue to work towards that. One of the main areas in which we focus for compliance is the avoidance of underage gaming. We know that's a significant focus of this commission. That will continue to be a significant focus of us in our operations at Raynham, as it is down in Ben Salem.
If we could refer refer the commissioners to Exhibit 5. You might be able to follow along.
Sure. Exhibit 5 reflects specific activities and efforts that we undertake in connection with underage gaming. Director Wells had noted the physical layout of our casino is about as well suited as you could have a facility for purpose of controlling entry into the casino. Our security officers are stationed at the entrances on a 24-hour, 7-day-a-week basis. There are multiple officers there during busy times, which tend to be on the weekend periods. But as indicated in Exhibit 5, in an average month, we check identification of about 600,000 people. That's about 50,000 people a month. We actually stop, require them to produce identification, and either turn them away or allow them in. Anyone who appears to be 30 years of age or younger is stopped and required to produce identification. The identification that's required, by the way, is either a state-issued identification such as a driver's license or an ID card, military ID, or a passport. We get all types of identification, but most often it's a photo driver's ID license. Persons who appear to be under the age of 30 but who are over the age of 21 are then issued a wristband. And that wristband tells all of our staff on the floor that this person has been stopped, has been checked, and is over 21 and had the right type of identification. We change the wristband color every day so that counterfeiting is minimized among those who might be trying to get in. Also, anyone who has been issued a wristband who possibly leaves the property and then wants to get back in is again checked at the entrances to make sure that that person didn't get the wristband from someone else. Any person who has an ID check completed who has fake credentials is detained, state police are called, and the state police then take the matter, but those persons could be subject to arrest in the discretion of the state police. Another procedure that we have in place that greatly facilitates the prevention of underage gaming is the fact that we empower and encourage all employees on the floor in front of house customer service positions to stop and check people who appear to be under the age of 30 if they haven't been given a wristband. And different people, I guess, think 30 looks differently, but we have numerous occasions where folks working on the gaming tables, for folks working in our environmental services department, or security officers actually on the floor, not at the entrances, will stop, ask people to produce ID, and verify that they are of the appropriate age. So just in summary, we think that these procedures have been a significant contributor to our relatively low incidence of underage gaming incidents that have occurred. And if you take a look at Exhibit 4, you'll see that in recent years there have been relatively fewer underage infractions than there were in some of the earlier years when we were learning to develop procedures and learning from things that perhaps could have been done a little bit better. The final issue that I wanted to discuss is the DEP consent agreement, which Commissioner Wells had also referred to in her report. Mr. Rickey had mentioned that we have a huge horse population at our property, 1,400 horses. They make a lot of mess, as you can imagine, and we have to deal with that literally on a daily basis. We also have to keep in mind that we have a 450-acre site, and the majority of that acreage remains as open space. So we preserve that open space, but it presents certain challenges given the big population of horses that we have. The issue with DEP began in the mid-90s with a consent agreement that was put in place then, and over the 20 years that transpired between then and now, regulations changed, things became a little bit more stringent, and we found ourselves struggling and working hard to comply. The main problem was rainwater that would mix with spent hay and straw that was manure laden. The organics would mix and run into our retention basins, and basins that were designed to be traditional stormwater retention basins became organic laden basins that had relatively sewage in them, which was creating problems because these basins are designed in heavy rains to fill up and then overflow the banks into an adjoining stream, but the organic mixture in the basins became a problem. So ultimately, we came to an agreement in 2011 with DEP where we agreed to pay the civil penalty, but more importantly, that consent agreement details a series of improvements and best practices that we were required to put in place in order to make the condition better. We have done most of those things that are required. We've done everything required on schedule. There are some additional things that are scheduled to be done in the coming years. One of the most important things we got in that agreement, and it was at our request, was the opportunity to ask DEP to allow us to make a change in one of our drainage basins that is now connected to the sanitary sewer system. When we accomplish certain things in that consent agreement, we are permitted to go to the DEP and ask for relief with respect to the sewer connection. We originally envisioned that that would not happen until 2016 at the earliest. We've done so well with these new procedures we've put in place that we just this week filed a request with DEP to terminate that sewer connection because the water quality has improved, we believe, to a point at which that would be appropriate. And that concludes the remarks that I wanted to issue with respect to compliance and regulatory matters, but I'll be happy to address any questions.
I just have one additional question for Mr. Bonner. Mr. Bonner, you indicated emphatically that you're very proud of your compliance record, and I know that's in part because you personally and others put so much effort into it. But I also know that you spend some time reviewing comparative statistics of compliance statistics of Pennsylvania casinos. And do you view parks as having a favorable compliance history given their volumes as compared to other Pennsylvania casinos?
We definitely do. We, I mean, on a raw dollar basis, we have paid less in gaming-related civil penalties than some other operators have paid, yet our volumes are so much higher than most other operators because of the number of machines and the size of our casinos. So I think on that basis, and on any other basis in which you look at it, we have a very favorable record compared to other operators in the Commonwealth.
And is it fair to say, and I think you can see this from Exhibit 2, but is it fair to say that Parks' volumes are, in some cases, more than several Pennsylvania casinos combined?
That is definitely accurate.
Thank you. That concludes Mr. Bonner's testimony.
Bureau has no questions of Mr. Bonner.
Commissioners?
I have no questions.
Commissioner Stebbins?
Quick question. You talk about the three-member compliance committee. Without naming those individuals, can you at least tell us what their background, work experience is or career experience?
Sure.
The professions they come from.
One is a practicing attorney from whom you will hear today, Mr. Everett. I can tell you who he is. I'll tell you who they are. There's no confidentiality there. Mr. Kendall, who has a long history in gaming in the UK, and Mr. Budd, who has a long distinguished career in general business, is the third member of the committee, all of whom are outside. And banking and regulatory as well, Mr. Budd. So he brings that particular regulatory focus, although it's not gaming, to the compliance committee, which is extremely beneficial.
I was going to ask the same question. So this is the compliance committee of the board.
Correct.
Right, and it's made up of 3 members of the board?
Yes, sir. They're all directors of the board who serve on the compliance committee.
And have you thought about having members of the compliance committee who are genuinely outside the orbit of the organization?
I've not been involved in those discussions.
Is that for Mr. Green?
We certainly could consider that, Chairman. We felt that the fact that these members are all independent of management and operations was a significant enhancement to what otherwise might be if we had employee or executive members on the committee.
Yeah. Well, that's something I think it's worth thinking about. We've certainly dealt with that in other contexts, you know, and when difficult things happen, which occasionally they do, having somebody who's not in the network, a member of the board, not invested, doesn't have any financial interest outside of some kind of, you know, compensation, I think it's worth thinking about.
Take that under consideration, Mr. Chairman. Thank you.
Anybody else? Okay, ladies and gentlemen, I think we will reconvene. Yep. It's all right, take your time.
Yeah.
All of our council ready? Council, you all set?
Yes, sir.
Okay, Councilor Lee.
Yes, we're ready to proceed.
Will, excuse me, gentlemen? Guy? Guy? We're reconvening the meeting. All right, we're reconvening the adjudicatory hearing on the Raynham Park LLC application. Councilor Lee.
Thank you, Chairman. Thank you, Commissioners. Our next witness is Mr. Manukian. The examination is going to be done by his counsel, Counselor Everett. So at this time.
As Alan Kohler had mentioned, we're going to try to keep the questions to a minimum and basically allow Mr. Manukian to give a statement and then open it for questions.
Thank you for allowing me to come and address the Commission. I wanted to give you some personal background on me. I am an Armenian. My parents are Armenian, and my parents lived in Lebanon. My father always wanted me to have English education. It was the dream of people in the Middle East to send their children whenever they could and educate them, and especially for Armenians. It's of prime importance, the education of their children. So he sent me to England to go to school and university. After university, as the political situation was uncertain for Christians in the Middle East, my father wanted me to stay in England and start a family business so that the family would have a place to go to if necessary. I noticed during my years living in England that housing quality in London was poor. 5 bedrooms shared 1 bathroom. Office buildings did not have adequate bathrooms and were antiquated. By renovating this kind of property could add substantial value, and I saw that a perfect opportunity. With my father's help, we acquired the property, which was renovated, and as a result, it went up in value dramatically. This allowed the family to purchase further properties, which over time proved to be successful and very profitable. We were lucky to catch London as it began to become an international center. We ended up owning several properties in excellent locations. Around 1982, we met the Sultan of Brunei and his brother and became friends. He visited my house socially many times. At that time, Brunei was not independent, but a British protectorate. In 1984, Brunei became independent, and so they were in charge of their country's oil wealth for the first time. Immediately after independence, to my surprise, the first thing they asked me was if they could buy my house that I lived in, which it visited many times, which I did not want to sell, as I did not want to sell under any circumstances. This was the house where my children were there. This is where I lived. They therefore asked if we could come to Brunei and help them furnish their huge family homes down to the kitchen utensils and provide other luxury goods such as cars, paintings, jewelry, etc. This business was very successful and resulted in the accumulation of large wealth for my family and continued until 1994. In the middle of our business in Brunei in 1989, Bob Green and Richard Campbell brought to me the opportunity to purchase Philadelphia Park. I was very impressed by the large piece of land and its excellent location, property being my forte, so to speak. Bob Green was the CEO of a large gaming company in UK and was prepared to give all this up to run Philadelphia Park. This gave me tremendous confidence and trust, and I was absolutely right. He, Bill Hogwood, and Tony Ritchie managed to turn a loss-making track into one of the most successful in the USA, racing over 200 days a year, which it still does. In 2005, Pennsylvania introduced slot gaming. We went through regulatory investigations, and we were found suitable and awarded a license. We immediately started work on converting the grandstand to open a temporary casino to start generating revenue as quickly as 3 months. Also, at the same time, we started planning the new casino, which was opened in a timely manner. In 2009, table games were permitted, by the Commonwealth, and we immediately started work and installed table games. The facility today still looks brand new after 3.5 years, as your investigators have seen, because we are constantly on top of it. We replace furniture, wall coverings, carpets, and we are always making sure that our clients receive absolutely the finest service, and at the same time, the facility being in tip-top shape. We are looking at potential further expansions as we speak, including a showroom for our customers. You can't stay stationary. If you stay stationary, you go backwards. You have to improve all of the time, make things better, and provide more amenities to our customers. And the showroom we thought was an excellent extension to what we have there. We have one of the most successful casinos in the East Coast, which has paid $1.27 billion of taxes in the last 5 years alone, and employs more than 2,500 people, and that figure is going up by 100 at a time, 100% as we add more and more facilities, more and more amenities to our organization. If we're fortunate enough to be awarded the license at Raynham, we expect to repeat that success here and generate significant revenues for the Commonwealth. As a last thing, in all my dealings, I've always engaged top-notch counsel, accountants, and the most fantastic team of employees. When people ask me, what's the secret of your success? The secret of my success is given by God the ability to choose the right people. If I decide to be 5,000 miles away, I must have a phenomenal team of people that I can sleep at night, rely that they will do a fantastic job. And I've been proven right. Look at my team. Today I feel proud of what you heard so far. And that's what we will do again in Raynham Park. We've already, even though we might not get our license, we've already found and hired a top-notch man that we will be able to put immediately, if we are granted license, to move things forward. We're taking a chance, but good men are difficult to find. If you find them, you've got to get them. If we are not successful here, we use him somewhere else, because he is a good man. To ensure, and I've always ensured that we strictly comply with all legal and ethical requirements. For example, when I invested in Greenwood, the direction that I gave management and the underlying team to board members was that we should operate the business in whiter than white manner, and that we should not operate in any gray areas in any way whatsoever. When Greenwood received its gaming license, we established a very active compliance committee, independent of management, hired internal auditors to consultants review compliance with all regulatory requirements, from bank secrecy acts and currency reporting to gaming integrity and safety compliance. It is extremely important to me that any business in which I'm involved and carries my name or my family's name, it has to be excellence. We are not in any other business than that, and which complies within the law and in good business practices. Thank you for giving me this opportunity. I'm sure you have questions to ask, and here I am. I've come a long way.
Thank you.
I've come a long way to ask any questions that you have.
Counselor, are you finished?
I have no questions for him.
I have just a few questions. Good morning, Mr. Manoukian.
Good morning.
I'm sure it wouldn't surprise you that the Gaming Commission in Massachusetts is statutorily obligated to review how each gaming applicant proposes to achieve the goals of maximizing tax revenues received by the Commonwealth in connection with the gaming operations.
Absolutely.
And that's as a matter of its, you understand that's a matter of its statutory obligation?
Absolutely.
And that on the Gaming Commission's website, it has a mission statement, and one of the missions is providing the greatest possible economic development opportunities, of course, but also maximizing tax revenues for the Commonwealth. You understand that as well?
Absolutely.
So, do you, participated in an interview with the investigative team here some months
Correct.
ago. Do you recall that?
I recall that.
Okay. And I'm just gonna read for you a very brief quotation from your interview and ask you if you can remember saying that to the investigators. You were discussing taxes, and you made a general comment, and I'm quoting now: "We use all legal means to pay as little as possible. In governments, they try to get as much as possible." Do you remember saying that?
Frankly, I don't specifically remember that. In what content?
Let me, I'll
If I could make a comment, we have never seen, although we asked for it several times, we were never given a copy of the testimony that was taken, although I understand other people have received it. So we've never seen this testimony or been able to comment on it.
Okay. I'm not aware that there was a request for Mr. Menuchian's sworn testimony, and honestly, I don't think we need to belabor the point, because I think that will be the only provision of Mr. Menucchi's testimony that I want to ask him about. Let me ask it a different way then. Would it be fair to say that your operations, Mr. Menuchian, use all legal means to pay as little tax as possible?
Well, as I said in my short statement, you come to a new country, you want to start, you are going to invest large sums of money. The first thing you have to do is find yourself a lawyer and an accountant to set up from the beginning in a proper, legal, correct manner. Because you come from abroad, you have no idea what are the laws. For instance, United States of America. When we came here to buy Greenwood, I hired one of the largest firms in Los Angeles, which he is a member of, and we hired top English accountancy firm to advise us what is the best way of investing in America. And we were told that the 99% of all investors that invested, we are going back 1990, use the Netherlands Antilles rules, because this is a country which has double taxation treaty with America. I don't understand. I'm not an accountant, and I'm not a lawyer either. And they said this is the procedure which is followed. And then they introduced this highly complex structure, which I myself find it extremely complicated. But within a very short period of time, the law was changed, the double tax treaty was stopped. So it was all in vain, and we were stuck with this complex structure which was serving absolutely no purpose to anyone in any way whatsoever. And we are stuck with it today. It served absolutely no purpose. We pay exactly the same American taxes as any American company does. We have zero advantage. We have been audited since 1990, 22 years, by the IRS. The regular audits they do to every large corporation every 4, 5, 6 years. We get that audited, and the last audit was only lately, and we came up with flying colors with no adjustment for a company of our size. Our turnover, to come up with no adjustments, is a total. I picked up the phone, I spoke to Tony, I said, "Congratulations, Tony, for running such a tight ship." I rang up Tom Bonner and I told him, I thanked him. Really, we have this huge turnover in a very regulatory environment. We cannot be anything but whiter than white, because otherwise you will be perfectly right to criticize me. And we are not. And
Mr. Menuchian, let me, do you have a copy of the, it's exhibit number 4, which is the report that was prepared by the investigative team here. And if you could flip to page 51. I want to focus the discussion just a bit on this tax issue.
yeah. Yes?
And do you see the paragraph, that first full paragraph beginning on the page? I'll just read the first sentence into the record, if that's okay. Relative to the so-called, quote, tax dodging, unquote, issue, Manookian indeed created a complex ownership structure for his holdings in Greenwood Racing that enabled him to take advantage of the then existing tax treaties between the United States, the Netherlands Antilles, and the Netherlands. Did I read that correctly?
Correct, yes, absolutely.
Do you, and as I understand it, the way that works is there are loans from these offshore companies there are loans from these offshore companies that are made to your American businesses at a certain rate. And the interest that's paid on those loans is not taxed in the offshore jurisdiction.
It's not taxed in Netherlands.
Correct.
Yes.
And at the same time, the business enterprise in the United States, which is the borrower, is deducting that interest expense from its own books.
Correct.
Could you tell the commission whether that's a financing structure that you would intend to use for your operation in Massachusetts here?
But it is not correct. The interest is paid, that is paid to Kringle NV. Let's say Greenwood pays $100 interest to Kringle NV. It is a tax deductible item. And the $100 that Kringle receives, I pay 30% US tax before the money gets to Netherlands. That is the fact.
I think Mr. Mackey,
it's
clarify,
very simple.
to clarify.
I do pay 30% tax on the interest that I get. So, are you aware of that, yes?
The issue, I think, Mr. Mackey, I think Mr. Ricky addressed this. If you take a look at the exhibit, which was the exhibit on the capital structure of Raynham, which is exhibit 5, or exhibit, is it 3 in your document? We wanted to make it very clear, because of your concerns, that the Raynham Park capital structure does not include any shareholder loans from the shareholders of Greenwood, et cetera. So any financing is coming from Greenwood, which is a U.S. company. Any interest that's paid is completely taxable to Greenwood as a U.S. company. It's not intended to have any of these offshore companies make any loans or put capital directly into the Raynham Park capital structure. So the fact that these companies exist in no way affect the Raynham investment or are going to be involved directly in making money into it, paying money into it. So I thought we covered that, but we can certainly cover that again if you'd like.
Let me just ask, with respect to Mr. Manookian, you referenced the 30% withholding that you that the U.S. operation pays before it makes its interest payments to the offshore entity. What about with respect to state taxes? How does that work?
State taxes?
The Commonwealth of Massachusetts, for example.
Don't know, so you don't know?
No, I don't know. All I know that if I receive $100 interest, $30 goes to the taxman. That's all I know. How is the technicalities worked out? I do not know. State taxes? No, I don't know.
I think maybe we can get to the heart of where you're going, Mr. Mackey. Mr. Manookian, I think this was covered, just to be abundantly clear. The structure that you had in place, referred to on page 51, do you have any, not that you could...
The structure which was set up in...
Do you have any intention of structuring Raynham Park LLC like this?
Absolutely, you can record it. It's recorded. Absolutely not categorically in any way whatsoever.
Okay. I think that may have been the point that you were trying to get to, Mr. Mackey. Okay.
Absolutely not. The money will come from Greenwood, which is an U.S. corporation. It will not come from my holding company or me personally. Clear.
If I could ask if you would ask a clarifying question. There was a comment made or a question made about the desire to minimize taxes. Well, I will tell you, as an individual in the United States, I like to minimize my taxes. It's a goal that I try to do if I can lawfully do it. But isn't it in your interest, similar to what we have in Pennsylvania, where the state is our partner, that to maximize the gaming revenue, because that maximizes the income to you and it maximizes the tax revenue to the state?
Absolutely,
Thank you.
absolutely.
I have no further questions.
Commissioners? Mr. McHugh?
Let me just look a little more broadly, Mr. Menuchyan. You've obviously been very successful. Do you pay taxes personally in any jurisdiction where you reside?
I pay taxes in any jurisdiction that where taxes due. Yes, I do.
No, that wasn't quite my question.
I do pay taxes.
And you pay taxes, you've described, to Pennsylvania through the withholding on
Yes,
the
because
interest.
I don't draw salary. I don't.
Right. So I understand that. Do you pay taxes in any other jurisdiction where you reside?
Yes, I do.
Which one?
England, UK.
And for how long have you paid taxes in England?
Over the period that I've been there.
Did you read you read the report of the IEB? Did you?
You mean this report?
Yes, that
Yes,
report
I
that's
do.
Exhibit
Yeah.
4.
Yeah.
And did you observe in that report statements to the effect that all of your companies are located in jurisdictions where no taxes are due?
Yes,
And is that accurate?
it is accurate. Yes.
All right. So you have, as a personal approach to taxation, chosen to locate your companies in jurisdictions where they do not pay any taxes.
Correct.
And
Well,
what?
I mean, they do. If it's due, we do pay. I think Coringal tax accounts were submitted to you, haven't they?
But
Just to clarify, for example, all of the Greenwood operations, et cetera, pay huge amount of taxes.
I understand that.
There are taxes payable in the Netherlands Antilles. There are taxes payable in the Netherlands. They have a different tax structure than the United States, so they're not comparable, and the tax rates are not as high, but there are taxes that are paid in jurisdictions. Those returns have been submitted to the staff, whatever the tax returns have been filed in those jurisdictions. But there are a number of jurisdictions that do not have income taxes. For example, Mr. Menuchyan is a citizen of Lebanon. It has no income tax. I wish I was a citizen of a country that had no income tax. But
All right. What role do you intend to have, Mr. Menuchyan, in the operation of the entity at Raynham if the Raynham entity is the successful applicant?
I will myself be involved in every doorknob, every screw, the quality of the workmanship, the way the time and motion study to make things function beautifully. I will be involved in all aspects of that construction because I love it. It's my hobby, and as far as day-to-day operation, none at all. I have the most fantastic team of people. They are more educated than I am. They are experts. I will let them get on with it.
So you intend to be involved heavily in the construction operations, but not in the operations?
Not the operations. No, I have not. No.
What role do you have in the operations of Greenwood Racing?
None at all. I pay the role I pay again. It's a constant development project, and I'm now participating in the design of the showrooms, for instance. I love to do that, and it pays dividends. You know, we came in as amateurs. MGM, Harrah's, they all looked at us in Pennsylvania. Who are these bunch of jokers? They're gonna eat off our plates. We built a facility better than theirs. Go and see Harrah's facility. We beat them every month. You know why? The people that I employ are excellent, better than theirs. So I will be only involved in construction.
All right, I have no further questions.
Commissioners?
I have a question. The report mentions that the capital structure and ownership structure that was put in place to take, that is not your intention to put in place here in Massachusetts, was generally put in place to take advantage of tax treaties that no longer exist.
Absolutely.
It also, the report also mentioned that you have the intention of streamlining those structures. Could you speak a little bit about that?
Ask him. Ask him. The lawyers write the law, they make the rules, and they complicate things as much as they can. Okay?
As he's surrounded by them.
You know,
They build by the hour.
you have to be, you have, sorry, look, too many lawyers here. I'm very sorry, guys. You know, and I mean, they write the laws and they execute it. And what it bothers me, even worst of all, they write me 11-page letters and they ask me, can I have your opinion? I say, if I could give the opinion, why would I need you? And nowadays, they give an opinion and they want a way out as well. So I mean, I've got used to that.
Maybe
You
to
kn-
answer your question, I can get to that. The structure, that structure was developed at the time that everybody was using that structure back in the 1990s. In '94, the treaties were renegotiated and any benefit from that was removed. Unfortunately, we're stuck in those countries. In order to get out, it would take multiple years and would be very costly to change what we have right now with no benefit. You know, it's of no benefit to us, but it's of no detriment. So, you know, it isn't going to be involved in any of the Raynham Park. It's not going to loan money to Raynham Park or anything else. And if it was, it would be no different than Mr. Mnuchin or any other company lending, because it would be subject to the same tax rates. There's no benefit for it anymore. So I hope that answers your question.
I need 2 lawyers to verify what he said. You know, and I will not make a millimeter progress, I can assure you, you know. So, you know, unfortunately, we are stuck with it. I agree with you. It's unnecessary complication and difficult to understand. I agree with you totally. You know, it's very difficult to understand, but it is what it is. I'm stuck with it.
Commissioner? Other questions? Is that okay? Commissioner Stebbins?
Mr. Mnuchin, just a quick question. You referenced the fact that you have identified a person. I don't think you've hired them yet, but you've identified a top-notch person to manage the facility in Raynham. And then subsequently, you just talked about you hired good people. So is, I mean, I compliment you for being that far along that you've identified somebody to run the facility even prior to being awarded the license. But it would lead me to believe you're also interested in the hiring of your management. So it goes a little bit beyond the construction of the facility. It sounds like you still want to have a hand in who the people are.
My top-notch people, I like to look at them in the eye. I want to see them myself personally. I've chosen to be away long periods of time. I have to pick up people with great integrity and honesty. This is a very, very, very important business. If you don't have absolutely top people, you can get yourself into all sorts of trouble. And I don't intend at this stage in my life to have a hairline, something bad that carries our name. And I like to say, in fact, we have hired the person, haven't we hired?
Is it?
We've actually hired, and when did he start?
July 8th.
July 8th, and he's West Point graduate, Harvard business, and then Wharton Business School graduate.
Just to clarify, if I could, the person was recruited and hired by management. Mr. Mnuchin met him after the fact and was very impressed with him. Okay. So he didn't actually go out and recruit the person himself, nor did he vet the person beforehand.
No, we go to a firm that give us something. Okay.
That's all.
I just have 2 quick questions. Mr. Mnuchin, have you ever been charged by a law enforcement agency with illegal tax avoidance?
Absolutely not, never.
Have you ever paid any significant penalties to tax agencies for tax practices?
I have paid not a single penny in penalties to any tax authority anywhere in the world.
Thank you. Do we have any redirect,
That's it.
No, redirect, Chairman.
recross?
No further questions for the witness. I'd just ask on behalf of the Bureau if we could have the name of the person who was recently hired to determine whether or not they need to be qualified and reviewed.
Yes.
To sort of complete the circle on that, that person has been hired to work at Parks Casino. That is what they currently do. There certainly is an, as Mr. Manoukian described, there certainly is an eye towards that person potentially running the casino in or the slots parlor in Massachusetts if we were so lucky to get the license. But he is not hired to run the slot parlor in Massachusetts. He is hired to work at Parks, and he does work at Parks, just to clarify.
At the moment, he is in Parks.
All right. Well, that's fine then. We'll withdraw that request.
One last question, Mr. Manoukian. Where do you call home, sir?
Well, you know, we have homes in London, we have homes in Los Angeles, we have homes in Lebanon, we are going to be building a home in Armenia now that it is independent. But psychologically, I consider home to be England because that's where my children were brought up, that's where they went to school. I would say, as a whole, I would say London is my home.
Thank you.
But my children, it's a different story. I mean, what they're going to do in the future.
Thank you.
Anybody else? Thank you very much, Mr. Manoukian. Thank you for making the trip.
Thank you. Thank you for having me.
It being a few minutes of 12, I think we will take, is 45 minutes enough? Take a 45-minute adjustment, adjournment for lunch and reconvene. Let's make it at 1:45.